So the Corporate Transparency Act. So this is an act that was put into place by FinCEN. And when I say FinCEN, most people look at me blankly and they're like, I have absolutely no clue who that is. So the question is, who is FinCEN first off? FinCEN is basically the criminal division of the IRS. That's that. So what they have done is they have come out with laws that they have enacted, and these were actually enacted back in, I think, 2021. And so what they did is they put this stuff into place, but the second they do that, people start quarreling and fighting, and things didn't happen to allow it to get into place. So it became effective January 1st of this year. So January 1, 2024 was when everything kind of kicked into gear. And so basically the purpose of the whole thing is that, and I'm going to use their words on this one, not mine, because I'm not sure I totally agree that their words are correct, but basically it is to help catch people using business entities for illicit activities. So think money laundering, fraud, terrorism, those kind of things. They're concerned about LLCs and corporations and other registered entities being used to basically kind of do this stuff and hide, is what it's going to be. They also say that it is to set a federal standard for incorporation practices, which are historically state law, to protect commerce, help national security, bring the U.S. into compliance with international standards. That might be closer to what the actual intention is. And then they also just want to know who owns the company. So ultimately, when you go file your entity, all states have different requirements on what it is, whether you're going to file an LLC, which is called a limited liability company, or a corporation, which I think most people are familiar with because those have been around for eons as far as I know. And then any other type of registered business entity, which it can kind of like slide from there as far as like how many different types of entities you can go depending on what state you are in. And so if you go to like a state like Missouri, like if I go form an LLC for you and you, for example, use a registered agent company, one that I run or somebody else like that, your name is actually never listed in any kind of public record. We're one of just 2 states that actually do that, but it's kind of one of those nice conveniences to help hide behind the business because you've got this nice corporate veil to hide behind. Why would you want everybody to be able to know who is actually running the business? Because that helps you avoid frivolous lawsuits, those kind of things that are actually taking place. So I kind of talked a little bit about where the law came from. And so in that there was some fighting to delay the effect of not starting until 2024. Well, so since it started, there have been several lawsuits that have been filed. The National Small Business Administration, not Small Business Administration, the National Business Alliance, I think, has been filing a couple of lawsuits. One of them was in Alabama, to where what actually happened is the federal court in Alabama ruled that this is not a valid thing that they can actually do. So this is not within the powers of what FinCEN can actually do. Because if you think about the IRS, they're part of the executive branch. They're not part of the legislative branch. They're not really there to go expand their own powers without permission from somebody else. Again, my take on it. But what has happened is you've got that. It's in the appellate court, so everything has been effective. So what FinCEN did when they lost this case is they appealed it. And basically what they said is that the plaintiffs in this action are not required to comply, but everybody else in the entire nation still has to comply. So we're still at this, and we're still trying to make sure that everybody can be helped and do those kind of things. I think at the beginning of June, 22 states have actually jointly filed what's called an amicus curiae brief, so essentially supporting the plaintiff's action in the federal courts during this appeals process. All right, that's the boring legal stuff, but everybody asks, like, do I really have to do this? And so yes, the answer is you do have to do it, but there's the possibility that one day we might not have to. We'll see. We have no idea where that's actually going to come out. And if it helps, I have actually sat through a continuing legal education on this stuff where we dove more into the case law and stuff like that. So I won't bore you with the full extent of what all that kind of stuff is actually going to be. So the big question is, who has, who has to report? So first off, it is going to be based on the actual business entities. If you are a small business, there's a really, really good chance that you are going to have to comply with everything that is here, and you are going to have to file what is called a beneficial ownership information report. And so there are 23 different exemptions for people who don't have to file on that one. So, but if you have formed a business within a state, you do need to consider needing to comply with this. And if you think that one of the exemptions or something might apply, I would strongly advise talking to your attorney to make sure that you understand that you don't need to comply. Because otherwise, if you go get things filed, you'll at least be playing it safe and be on the safe side. So those that would meet the exception, generally speaking, are going to be entities that have essentially already filed with the government. So if you think about public accounting practices, broker advisors, banks, people who are registered at the SEC. If the government already has your information, they don't really care about you. They don't need you to do it again because they've got it already. 501c tax-exempt organizations are exempt, not nonprofits, but just the ones that have been determined to be tax-exempt. So that's where you start talking about your 501c3s, your charities, your public charities that you're doing things for, possibly private foundations, those kind of things. But if you go down the line of like an HOA, they may actually need to report, and then that gets more complicated as far as who would actually have to file on something like that. Because HOAs, if they're filed with the state, typically are not with some sort of tax exemption, because you file your nonprofit, then you go to the government and you ask for the tax exempt status. So they don't go hand in hand. So you could have a nonprofit without having that, just like an HOA is a good example of that. Entities that are controlled by another exempt entity is another exemption that they've got on here. And essentially what that means is, say for example, you've got a entity that is exempt because it's an inactive entity. We'll get into that one in a second. And it owns another entity that happens to be inactive. You don't have to file those kind of things. If it's been around for, this is the non-active stuff, so if it has been around for more than a year and it's not active, and how they define active is going to be that hasn't changed ownership in the last 12 months. It has earned less than $1,000 in basically gross sales less than $1,000 in gross receipts in the last 12 months. And then it does not own another entity that would have to comply with the law otherwise. And so all three of those have to be met to be considered an inactive entity. So you could be running something today, and if you decide to wind down the business and things like that, today you've got to file. But a year from now, you might be able to refile and update things and list yourself as an exempt entity at that point in time. So there are ways that you can kind of get out of the filing requirements going forward, and I will get into what that is a little bit later. Another one is a great one, is that if they can get the Secretary of the Treasury, the Attorney General, and Homeland Security to all agree that you don't have to report, that's an exemption. I just want to meet the entity that pulls that off, because I think that would be pretty impressive. And then large companies. Yeah, go ahead, Jeff.
I got a question, just to make sure I understood. That Alabama case, they basically won that. There's 22 other states saying we're going to follow on the same breath, but the IRS is saying, well, we're going to let this entity, but we're still pushing forward.
They are, because what they've done is they've appealed it, so the law is not finalized yet. And so essentially what... Correct. So what is going to happen is this is going to have to go climb through the appellate process and eventually get to the U.S. Supreme Court before we have a resolution. I mean, who knows how long that's actually going to take. So you'll sometimes see things expedited. They get up there. I don't know if this is an issue that they would actually expedite. They would just get it on their normal timeline. So you might not get a resolution from this until the beginning of 2026, for example. So, but what happened with those 22 states is they have come in and they have actively supported the case. And so they have filed a brief that basically just tells why they think that this is the correct ruling and that they're encouraging the courts to go ahead and do that. But as you guys know, the courts are just as political as everything else that's in the government. So we'll see. I think it was strategically filed in Alabama for a reason. They figure out what state courts and what judges and things like that can actually get things done. But that's kind of where it is right now. So we're just in a holding pattern, knowing that we all do still have to comply. And let's see, and we kind of talked about this before, subsidiaries of exempt companies don't have to file, so they're exempt, and you have a subsidiary that's exempt, that doesn't have to file. And then also, if you own multiple entities, something to remember is every single one of your entities has to file. So I own like 8 different LLCs myself, and I've got different things doing various issues. All 8 of my entities will have to have a report, even if the report looks very similar to the other ones. They don't really care. So my law firm's got a report, my smoothie shop's got a report, Lex Launch has a report. Every single one of these that makes money is going to have to comply with this, and there's nothing that I can do about that. And then that gets complicated because, for example, I'll have a lot of clients who own holding companies. A holding company is a company that just owns other companies. We do it typically for tax purposes, to try to maybe tie things together or sometimes to simplify ownership between various companies. But the holding company is going to have to comply. The subsidiaries that it owns are all going to have to comply. So when you get into this, like if you're a busy person, if you're actively engaged in running businesses, investing in real estate where you're putting those into your own properties and stuff like that, you're going to have a bunch of different individual entities that have to comply. When I get into the real estate side, what you'll find is a lot of my clients use what is called a series LLC. And basically what a series LLC is, and this is activated in I think 16 states, and Missouri and Kansas are both involved in that. But what it is basically you go create this LLC, and then you can create a bunch of series underneath it. And what that is just a bunch of individual LLCs is what it is. When you go file with the state, everything looks like, especially in Missouri, that it's all filed within the same LLC because they're just branches that you're creating with some paperwork. But because they can each operate as their own individual LLC, they also are going to have to comply on each individual series. So I've not seen anything that says, just because it's already associated with it, they've never said that you don't have to comply. So at this point in time, we're assuming that you actually do have to comply. So then it comes down to when you're doing this, what is actually going to get reported. So the gist of it is they want to know about the business. What's the name? What state is it filed in? What address does it have? And then they're going to get down further, and then they want to know the tax ID number because it's the IRS, so they can associate it with all your tax records, but they're not communicating. Those departments are definitely not communicating. But then they get into who are the actual, what they call beneficial owners. So what this is then talking about is who are the actual owners of the business, and then that goes and that spirals into how do you define what an owner is. So you have to list all beneficial owners, which is going to be anybody with at least a 25% ownership interest in the business, or persons who exercise substantial control. They do go ahead and go through and define substantial control as well. So this gets tricky when you do start getting into those entities that own other entities, and you start diving into trust and those kind of things to figure out who is actually controlling what. But they're all steps that have to be followed so you can make sure that everybody that is getting listed on here can actually make sure that they are compliant and not getting into trouble. And I'll talk about penalties at the very end of this. So generally speaking, they've got a list of people who have substantial control. Your president of the company, CEO, CFO, general counsel, chief operating officer, or any other officer, regardless of title, that carries on similar duties to those people. So even if they're not a 25% owner in this, they are still going to have to actually comply. Anyone who can appoint or remove a senior officer or a majority of the board of directors. So if you go in and you have the ability to remove people that have decision-making authority, you have substantial control no matter what your ownership interest is in the business. Anyone who directs, determines, or has substantial influence over important decisions, which is really kind of what it all comes down to. And so that's going to be over like the nature of the business, the scope of the business, what it actually does, the finances of the business, or the structural components of the business itself. And that's kind of where we get more into like the legal stuff as far as like what the business looks like on paper. Or they have this nice little catch-all at the end. If they think you have substantial control, then you need to comply. And so that's kind of that, they just throw that big gray area stuff out there because that's just kind of what they like to do when they go create laws. Information report is going to include, like I said, the legal name, address, and taxpayer ID. When you get into the owners, what you're going to need to provide is you're going to have to provide legal name, date of birth, current address. You're going to have to provide them with the ID number on a state-issued ID that you have, or a passport would qualify as well. And just you're basically giving them all of your personal information is kind of what it comes down to. You do have to actually give them a copy of a state-issued ID. What will qualify for that is going to be like a state-issued driver's license that is not expired, a state-issued ID that is not expired, a passport that is not expired, and like you need to have one of those things. But the state-issued ID can be from any state government, any local government, or from an Indian tribe if that's how you have your ID. And then the one thing that I kind of skipped over when we were talking about the big business stuff, and so we do have a line for if your business is big enough, you don't have to comply as well. And so that is going to be over 20 full-time employees, and this is all of these, it's not just one of them. Over 20 full-time employees, you have to have a physical presence in the United States, and you have to have more than $5 million in gross receipts in your company. They basically assume if you have grown to that size, they probably already know everything about you anyway, so they don't need you to go ahead and file one of these reports. And you'll see there will be lots of shareholders in there. So that report would be kind of a mess to figure out who has control and who has 25% and all those different kind of things. So when do you have to have this filed is the next big question. So everything was enacted, as I said, January 1st, 2024. If your entity was created before that date, you need to comply with your first report no later than December 31st of this year. So for those older companies, those established companies, a lot of my clients that I'm working with, I'm advising them, hey, we're not actually going to file this until November or December because there are ongoing filing requirements that you may have to meet at some point in time, the compliance of whether the law is going to be valid at some point in time. But essentially, let's just put it off so we don't have to go repeat these same steps later, or that we didn't have to do it at all is kind of where I'm going with this. But if you feel nervous about it and you don't want to procrastinate until the end of the year, get it filed now. Like, they probably already have this information on us anyway. Let's see, if you have filed your entity after January 1st of 2024, but before the end of this year, from the date that the entity was filed with the state that you filed it in, you have 90 days to comply. So if you filed it on January 1st, you need to make sure that you've got it filed no later than March 31st. I'm not doing the 90-day thing in my head. It might be like April 1st or 2nd on there. But that's kind of what that happens. So if you formed an entity earlier this year on your own and you haven't done anything, I would absolutely make sure you get compliance done on time. Even if it's late, you go get it filed because there are potential penalties for intentional, basically not obeying it. Then they have it modified that after January 1st of 2025 and going forward, once you file your entity, the new report will have to be filed within 30 days of when that is. So they're kind of shortening that time span. So essentially, it's kind of a, hey, if you're going to file this, or if you're going to go ahead and start an entity, you basically just need to file a report the same day that you're doing it. So
once you file, so if we file in November, December, do we have to do this annually, or is it just a one-time?
So it is not an annual thing, but it's also not a one-time thing. So basically what happens is if your information that you have provided them, any bit of it ever changes, you have to go file an updated report is what it is. And the updated report technically is supposed to be filed within 30 days of the date of that occurrence. So if you go buy a new home for your residence, that's something that's going to trigger it. If you move your business, that's going to trigger it. If you change your name, that's going to trigger it. If you go have a change in ownership, that's going to trigger it. All of these different things could be things. One thing I do want to get into on this one, and because that kind of covered my next point, is a lot of my clients will also own businesses in their trusts. And when I'm saying trust here, what I'm referring to is what's called like a revocable living trust. It's what most people have. It's to do the estate planning side without gifting away your property or trying to do a lot of current tax avoidance or property protection or anything like that. It's you get your stuff, you put it in the trust, and that's kind of the deal. When you have a business entity, this is a piece of property just like your car, your house, or anything like that. So it is something that has to get incorporated into your estate plan. Those revocable living trusts, for the most part, are not registered entities. So they are not going to require an additional report for them to be filed. So there's that kind of pass-through concept that they have from the tax side, but it's a good way to think about it for the trust, that essentially when you have those trusts, they operate under your Social Security number anyway, and you're the grantor, you're the beneficiary. So really, it's still just you or you and your spouse, whoever it might be that's actually going to be operating that trust. My stance on that is you're just going to file it as you are the actual owners on it. So you just make sure that the grantors of the trust are the people who are still going to be the listed owners on the filing for the entity itself. Make sense? Okay. And some of you might not have trust and have absolutely no clue what I'm talking about. Yeah.
No.
Okay. So anyway, if you have a trust and you're concerned about getting this filed, talk to your attorney. That's the nice short answer. So you can make sure that it doesn't go qualify as one of those trusts that might have been a registered entity out there that would need to have a separate filing. Because when I go file these, if you've got multiple entities that are all kind of interwebbed or they're entangled, like there's one that we have to file before the other ones, because when you're doing this, they can give you, if you request it, what's called like a FinCEN ID number. And then that ID number can then be used to identify that person or entity going forward. And so you can, if you don't like giving your license, you can actually go register with a government website that I think it's Safe ID is the name of it. But essentially what will happen is you can go through there individually, get your license listed on there, and you can go get your own FinCEN ID, and then you can actually have that one to be used for any of the businesses that you own, as opposed to just continuing to offer your information over and over again. So one of the other things that you have to disclose, and I'm going to jump back a little bit on the actual filing of the document itself, if the entity has been filed after January 1st of this year, the person or the corporation that filed it has to be listed as a person on the business, as the person who is authorized to set it up. So out of all the LLCs that I have formed this year, my name has appeared in umpteen reports as far as that goes, and that's my license and everything like that. So one of the things that I'm actually requiring my clients is that if we formed it this year for you, I'm going to mandate that I have to do it. But I've gone and I've got my FinCEN ID and everything like that, so I don't have to go list those things over and over again, and it at least simplifies the reporting process for us. But it is something that you could do. I did have one of my clients go and figure out how to get that done, and then he sent me his ID. And when I went through as a beneficial owner and listed it, it did make the process a lot easier for me. So the question is, what happens, and this is my last thing here, so if you guys have questions, we'll have plenty of time for Q&A, but what happens if you don't file? And so what they have done is they've actually put in some pretty extreme penalties on this one. So the possible penalty for not filing is up to $500 a day, and they say that you're intentionally not trying to file, so I don't think they're looking for some sort of mistake or something like that. So if you're a month late on filing or something because you just didn't realize that you were supposed to do it and you've been operating your LLC that long or your corporation that long, I think you're still fine. You can still sneak in. There's not going to be anything that's going to be done at that point in time. But on the intentional side, they can also impose criminal penalties as well, which includes up to 2 years in prison and then also up to a $10,000 fine. So they're not messing around with this. They're basically saying you're going to comply, and if you want to go fight us on it, we're going to punish you in a way that hurts really, really bad. So it's serious stuff.
So I got all kinds of questions.
You're good.
Are they notifying people, or are we just all expected to recognize that this edict has come down from up on high? And what does it cost? And can you fill it out on your own?
Okay. So from a notification standpoint, I think they just expect everybody to know, because the two professions they kind of honed in on helping people find out are attorneys and CPAs. We do track this stuff. Like, it's just things that get in front of us. When you go to a Secretary of State website is where you would typically file a business entity. When I say typically, that's all 50 states and then some. But when you go and you do that, they have information that's kind of listed in there with links and stuff like that to be able to go find what to do. They don't really give an explanation of it like I'm talking about today, but it's just generally speaking, hey, you need to comply. That's kind of what they're telling you. But it's something that you kind of have to seek out the information. From the ability to file it, you can file it yourself. There's nothing wrong with that. Don't file it on behalf of other people, because that, in my opinion, is going to be practicing law, because I think there are some presumptions, legal presumptions that are being made about who is an owner and those kind of things. You'll see there's some sites out there. I'm not totally sure what they're charging today that'll help do it for you. But basically, you'll give them the information and then they will just go file it for you. I have run everything through my website, LexLaunch, and so Matt kind of talked about it at the beginning, but basically what LexLaunch started off being was a place for people to go get their LLCs formed. So I've got systems in place, automation in place that allow me to do it in a more cost-effective way. So I have gone ahead and I've created some software and some applications to put into place to help people get this done with me for a more affordable price, and I'm continuing to work with FinCEN on trying to get APIs and stuff like that in place so I can just make this even more streamlined. But our fee that we're charging currently is $95 per filing, or if somebody is concerned about having changes on a regular basis or just want to keep an eye on it, we'll charge $199 a year, and then you can file as many times as you need within that plan. So, and I think that's going to be pretty price competitive with the LegalZooms and the Inc.coms and those kind of things that are out there that are doing those kind of things.
So I set up my LLC, as I told you, through your LexLaunch, and today was the first day we've ever met.
Yeah.
But, so would you notify me about this? Like, rather than in this setting, but would you contact me?
Correct, yes. And so, so when you go through LexLaunch, everything comes with 15 minutes with me is what it comes down to. And so we've been sending out emails to people that did it before January 1st. And for people who are active clients, it's a part of the conversation that I'm having, because it's something that we need to have the disclosure. But I'll double check you just to make sure, because what...
I don't remember seeing anything, but...
People like to block my email. I'm just kidding. I don't send that many out, so I'll get people to put spam immediately on it. And I'm just like, I'm using like the marketing engines or whatever. I don't send out that much information, but I have been sending a few things out. I will make sure I get stuff out to you.
Okay, well...
Yeah, because the big thing is collecting the ID. Like, if I need to file it for you, I just need to get a picture of your ID.
The LLC thing was so easy through this, it makes sense for me to just let you do it.
I appreciate you saying that. That's my goal. All right, other questions, guys? Yeah.
So financial institutions have had to comply with beneficial ownership reporting for 5 years.
Mm-hmm.
And then the know your customer information since 9/11. So what's the difference between what we're already doing for each and every account that's open or maintained versus this?
The fact that banks are exempt, I'm guessing it's probably about the same thing.
Because we're doing it for all of our clients. So every time an account's open or a loan, any type of financial.
I would say it's because it's going to a different branch of the government. And so the banking regulations are not going to be overseen necessarily by FinCEN unless there's criminal activity going on.
The US Patriot Act.
Yeah. Okay. Yeah. So no, this is just additional compliance is what it is. So, Jeff?
What was the third thing you said? 20 or more employees, 5 million gross receipts, and,
Physical presence in the United States.
okay.
So,
All
because
those three things exist.
then you would be exempt from filing because you'll have foreign entities who, like I've got Australian clients that run business here and from, I think, China as well. But they will have to comply whether they're a large business or not because they're a foreign entity doing business in the United States. Laura?
So not to sound skeptical, but, so you said the IRS is overseeing this initiative, correct?
Correct.
I'm thinking about monitoring and execution of finding all these bad guys who are running fraudulent LLCs.
Uh-huh.
For various purposes. Have they hired a whole bunch of people that are going to be going out and looking for the violators? Because they don't have enough staff right now to do most of the stuff they're already supposed to be doing.
I mean, they supposedly just beefed up to like what, Bruce, 80,000 people or something?
They're authorized to hire 80,000 people over, I don't know, a 5 or 10-year period, but I don't know how many they've actually hired.
I don't think that many.
Responses are still not timely.
Yeah. Yeah, no. So it's technically the Financial Crimes Enforcement Network is what FinCEN stands for. So they're the ones that are overseeing this. I don't know that they have actually hired to deal with compliance on this matter. But the idea is that maybe they have, or they're creating some jobs with some government dollars. Yes, sir.
Okay, when coming down to the over 25% ownership on a small business, I have basically a one-person LLC
Mm-hmm.
Based out of the home.
Mm-hmm.
Now, would the over 25% ownership include a spouse?
It depends on how you have it structured. I think if you're in a community property state, and Jeff was talking to me about this at the beginning, but if that's going to be a different story because there is spousal ownership interest built into it. But like in Missouri and Kansas, we don't have that. We have either tenancy by the entirety or just your joint tenant with right of survivorship here in these two states. So the spouse would not be listed unless they're actually in the ownership documents with you. So if you have an LLC, that would be identified in the operating agreement itself. If you have a corporation, you'll see that would be done in the stock certificates. Or if you've set it up yourself and you didn't do any of those kind of things, I would look at your tax returns just to make sure that anybody that you've got listed on there is going to get listed on the beneficial ownership information report.
President, CEO, treasurer.
Correct, which is all him.
It's all me right now. But
Right. Now, if your wife is the president, then we know that she's the one that needs to be listed on there too. Other questions? It's all very straightforward, I understand. Okay. Yep.
Tim, you mentioned that you are listed, as an influencer on many of the things that you do. You are a third party.
Mm-hmm.
Would that mean, say, my accountant?
If they're formed as, sorry, Kirby, go ahead.
Well, just that they
Yeah.
provide, input. I make the decision, but they provide input. Would they need to be listed?
They would not. So the reason that I would get listed on those is because I formed the entity with the state for my client. So when I went in there, you'll see my name or my firm listed specifically as the organizer of the LLC.
Thank you.
Yep. Yeah, Kelly?
So, from a financial services standpoint, if like a financial advisor like myself, if I have an LLC, I still have to report, correct?
You do. Yeah, unless you are like the broker dealer. So, but I would still say you probably need to because yours is probably used more for like tax purposes than where you carry your license and hold it and everything.
Okay, thank you.
Yeah.
Well, like franchise locations for a company, does the CEO and COO need to be listed on each individual franchise? As
And when you say COO, CEO, are you referring to like the franchisor that is doing that, or as you have multiple locations and it's like the holding company that's?
So there's multiple locations with a main corporate team,
Okay.
CEO and a COO. Do they need to be listed on each individual franchise location?
I would say if they're going to meet the substantial control test on the entity, then yes.
That's the, you talking about the franchisor?
Or the franchisor.
So franchisor wouldn't get listed on there because that's going to be completely separate. It's if you have a franchisee that's got the structure where it's like a team that owns multiple franchise locations, that team could get listed on those subsidiaries, or certain persons could if they have control over each individual one. That's where you have to go to that substantial control test. But the franchisor side, that franchisor is just a licensing agreement essentially that's going down to the franchisee that is stating, hey, you've got permission to go run this business. They're not having any sort of control, and I say that super loosely because you understand they have all the control in the world, but they don't technically run your business.
Back to our conversation earlier before you started. Have a client, he owns multiple businesses. One of them meets these tests over, it's got 35 employees in one entity, the other entity only has 10. But as long as they're hitting that 5 million gross receipts, they don't have to report any of this information. So,
They've got to hit all three of those.
what's that?
So they've got to be the over 20, they've got to be over the 5 million, and the physical presence. If they meet all three of those requirements, then that particular
they have to meet all
entity,
three, not just
they have to meet all three.
Oh, okay.
Yep. So yeah, if you have one business that doesn't need to file, but another one does, the other one will need to file. You're not going to be able to group them all together. Like unless you've got some sort of setup where the subsidiary would be exempt in some form or fashion.
If the one business has to file, but the other one doesn't, does that automatically bring that one that wouldn't have otherwise had to file into the?
It doesn't. So they're totally viewed separately. So when you've got these businesses and you know this, each one has what's called a federal tax ID number, which is essentially like the social security number for the businesses. It's what it is. So they're all viewed as completely independent entities, even if they're connected in some sort of corporate structure. Yeah, Lisa? Nope.
If you utilize one of the services to report your information and sign up for that, is it like when you get a CPA to do your taxes, is that entity taking on the responsibility for the accuracy of the information, or is that still only on me?
That's a more complicated question because that gets into it would be just like any work that I did for any of my clients. Like if you give me bad information, I don't have a duty to go get a PI to go make sure that the information that you're providing is correct. So it's that the person that's filing it is going to be liable to the extent that they messed it up. But if it's based on the information that is reported directly to them, that's going to come back on the person that reported the information. Jeffrey, what was your follow-up?
I forgot.
Okay, sorry.
It's early yet. I only had one cup of coffee.
That's okay. She brought plenty. Yes?
You did mention trusts earlier. Regular trusts that are operating, like they just file a trust tax return and maybe it just has like an account in it per se. Do they need to be filing that report or no, unless it's attached to like a trust with an EIN?
That's where it starts to get tricky, and I think it needs to be individually looked at. Because if you have your own separate EIN, there's so many different types of trusts out there. I don't know if I could give you specific advice without actually seeing it.
And then you're back to the control, who's making the decision?
Correct, yeah, because then that does get more difficult when you get into the trust and the control and everything like that. Because you've got your grantors, your trustees, your beneficiaries, who has control of what, and like you could have multiple trustees listed on things. You have corporate trustees that could be stepping into place. It can get complicated when you start looking at those things. Okay. The information that I gave you on the website for Lex Launch, basically what that is, that's kind of telling you the exact site to go and find through. I was great. I didn't bring any business cards with me today because I really just don't network that much anymore. I wasn't even thinking about it. I've got a couple on me if anybody needs one, but otherwise, all of my information is available via LexLaunch or DinkerLawFirm.com. And if you go in there, I've got all the information that I talked about today, all spelled out to where I went through, I read the act itself, and I actually gave summaries of all the information.